Good afternoon, everyone. Can everybody hear me okay?
Yep.
We're gonna have the mics here in 1 second.
Oh, okay. I'll hang tight then.
There you go.
There, it's on. Okay, it's 1 o'clock, so I'm going to go ahead and call this hearing to order. It is 1 o'clock on the dot. For the record, this hearing is being recorded. We do have an attendance sheet at the back. I think everybody here, we've verified that everybody has signed in. But if we've missed you and you haven't, please do provide us your name. We just want a record of attendance to the hearing. If everyone could also silence their cell phones, just so that we don't have interruptions, just a little bit of housekeeping. I want to read the rules of decorum. I've set a copy of the rules at the back of the room as well. This is the protest hearing for the RE2 School Board Director Recall petition. All persons attending this public hearing are expected to behave in a professional and civil manner, and the hearing officer reserves the right to require persons violating the rules to leave the hearing room. Outbursts and interruptions from any person in the hearing room, including shouting, clapping, booing, laughing, or other reactions to the proceedings, are prohibited. Comments must relate to the matter at hand. The protest is in regards to the date the petition sections were turned in. So the purpose of this hearing is that it is statutorily required in the event a protest under Colorado Revised Statute 112-208(9) is received. We have parties here that will be providing us testimony. And I recognize Drew Kraniak. Is that how you say your name?
Yes, it is.
Okay, and Tony May.
Yes.
Do you both plan to testify?
I do not, and neither does Mr. May, unless he's needed for rebuttal purposes.
Okay, so I have oaths to swear a witness in with.
Okay.
So will either of you be like the witness for that purpose in today's hearing?
Not for our argument, however, if there's an argument that we may need to respond to, I suppose it's possible that Mr. may testify later on.
Okay.
So it's up to you if you want to administer the oath just in case, but I don't anticipate having him testify for me to present our arguments.
Okay. I would appreciate going ahead and swearing you in just in case.
Sure.
And then there's no harm in having an extra piece of paper, and then
Sure
it
thing.
won't disrupt the flow of things later. So if we could have our notary come on up. And then Willow, will you be testifying on behalf of the committee? If you could come on up and take an oath as well. And then Jackie. And will anybody else for either of your participations be saying anything? It's okay.
Yeah.
So these oaths are being notarized, and I'll just read it so that those that are in attendance know what it says. The oaths say, I do solemnly swear or affirm under penalty of perjury that the testimony I shall give in this matter before Hearing Officer Reiner regarding the sufficiency of the RE2 District Director recall petition shall be the truth, the whole truth, and nothing but the truth. And then there's a section for notary, so it's a sworn oath.
How are you doing? Fantastic. Could I, sorry, I was going to be three.
No,
Could I
it's
have you
okay.
Put your address there. Sign there. And sign there. Okay. Print on top and sign below.
Am I doing anything to not touch it?
You're just fine. Thinking through. And is it just Carly?
This is, yeah, it's Craniac, IAK, so that's what they like.
Okay.
Those are sent electronically
Nope,
as well.
that'll do it. Thanks.
Just
Good.
have them in paper for today. Here's a copy. Thank you. Copy for you.
One more exhibit that we'd like to introduce.
Yep, I will open it up for that. Remember, I'm at least providing the first four. Thank you. To
Thank
get
you.
started. Okay, I have received the sworn oaths, and I find them to be complete. Thank you all for doing that. The next item on our agenda is just to talk about the relevant statutes, and the relevant statutes were listed in the protest. The first one is CRS 112-108 7.5. It states that the petition may be filed at any time during the 60-day period after the designated election official's approval as to form of the petition as specified in this section. The next statute that was listed in the protest has to do with computing time. CRS 11106(2) states, in computing any period of days prescribed by this code, the day of the act or the event from which the designated period of days begins to run, shall not be included, and the last day shall be included. Saturdays, Sundays, and legal holidays shall be included except as provided in subsection 4 of this section. And then subsection 4 states, if the last day or any act to be done or the last day of any period is a Saturday, Sunday, or legal holiday, and completion of such act involves a filing or other action during business hours, the period is extended to include the next day, which is not a Saturday, Sunday, or legal holiday. So those are the statutes that have been highlighted so far. The next thing on our agenda is to talk about exhibits. And I provided each party 4 exhibits, and I'll just talk about them out loud so that the audience knows that what we're looking at and for the benefit of the recording. Exhibit 1 is a copy of the approved recall petition with a stamp on the top that was signed by Jacqueline Harmon. The petition was approved on November 24th, 2025. First day of circulation was November 27th, 2025.
That's 2023.
Oh, I'm sorry.
It's that box.
That 3 looks like a 5,
Yeah.
and I knew that, I'm sorry. The recall petition was approved to form on November 24th, 2023, and the first day of circulation is November 27th, 2023. Thank you for that. The next exhibit is Exhibit 2, and that is a letter from Clerk Harmon to the committee, which outlines the approval and the dates of circulation in summary. The third exhibit is a copy of the actual protest that was filed with Clerk Harmon on March 11th. And the last is an email provided to us by Mr. May that has a date stamp of the date that the petitions were received in the clerk's office, which looks like January 26, 2024. So at this time, I will acknowledge the protesting party. If you would like to provide any testimony or additional exhibits, please go ahead.
Of course, with your permission, we do have one more exhibit that I'd like to distribute. And then in lieu of testimony, with your permission, I'd like to provide a statement with a little bit more of a basis for Mr. May's protest. Can I approach with these
Yes,
exhibits?
please.
There should be 4 copies.
Do you want to give the other two parties copies?
Sure.
Oh, yeah, I forgot about that.
Yeah, it should be marked Exhibit 5,
Oh, he does have it labeled.
but if you want to do something else with it.
That's what ours would have said too.
Okay, so
Be wary of the wires.
I know Willow, who else am I?
Willow and Jackie.
Oh, and Jackie, of course.
Okay, and then you wanted to provide a statement along with the exhibit?
Yes, please. We appreciate the opportunity to be here. Again, my name is Drew Kraniak. I represent Mr. May in this matter. The reason why we're here today is, as you noted, protest of the sufficiency of the recall petition that's been circulated to recall Mr. May from his board position. It's our position that the protest, that the petition and the circulation is insufficient. And the basis for that is that the committee has failed to submit all 99 sections that they compiled, signatures to recall Mr. May. Each of those were filed untimely per the statute. When a statute is unambiguous, public policy considerations beyond the statute's plain language have no place in its interpretation. Here, the statute that you referenced, Officer Rayner, is clear. The time limit permitted to circulate and to file a recall petition is unambiguous per Colorado Revised Statutes 1:108, 1:12, 108, 7.5, using the computation of time in Colorado Revised Statutes 1:106 that you also referenced. Administrative agencies or their officials are without power to exceed the authority conferred by the statute. What I anticipate hearing from other parties is that they were under the impression that they had an extra 3 days to provide the petitions to the clerk and recorder. However, that isn't true under the statute. If that was permitted here, then essentially it's an argument that the laws passed by the Colorado State Legislature do not matter. Or you can pick and choose which portion of the laws you want to follow and which portion you don't want to follow. For example, if you allow an extra 3 days beyond what's permitted by Colorado law, could you not also allow the number of signatures necessary to trigger a recall election to increase beyond what's put in the Colorado Revised Statutes? Could you not allow that number to be decreased at your discretion? Clearly that's not permissible, and neither is allowing an extra 3 days beyond what's permitted in the statute. Regardless of that official's intention in stating time limit that isn't consistent with Colorado law. Broad claims of fairness or equity don't provide the officer or the administrative official leave to provide relief not contemplated in the statute. I'll try my best not to get too far into the weeds here, but there is a case that was decided in 2023, and for your reference, Officer Rayner. This is the case of Rudolph Fontenary, trustee, versus Colorado Mine Land Reclamation Board. And the citation, if you are interested, is 529 Pacific 3rd, 615, and it was decided by the Colorado Court of Appeals. In this Fontenary case, a party requested a hearing with an administrative board 30 days after the issuance of a proposed decision. I'm sorry, let me back up here. The party requested a hearing within 30 days of the publishing of a proposed decision by the board. However, that's not what the statute provided. That's not what the statute allowed. The statute allowed a request for the hearing within 30 days of the issuance of the proposed decision. There was a Colorado regulation put forth by the board that allowed the protest and the request for hearing within 30 days of the publication. However, that was inconsistent with the Colorado revised statutes with Colorado law. What the Colorado Court of Appeals determined in this case is that, frankly, it didn't matter what the regulations said. If the rules put forth by the administrative agency conflicted with Colorado law, then Colorado law, Colorado statute, trumps whatever comes out through agency rules. Therefore, in the Fontenary case, the request for the hearing was untimely, and the board had no jurisdiction to hear the plaintiff's arguments. That's very similar to the situation that we're in right now. Regardless of what was communicated by any officer of the state, the law is clear. The committee had 60 days from the date that the form was approved by Ms. Harmon to file with the clerk and recorder. They did not do so. Therefore, neither you nor I nor anyone else has any power or authority to extend that period where it is clearly given and limited by law. I expect there will be arguments about fairness and loopholes and technicalities. That's not what we're dealing with here today. We're not dealing with a technicality or a loophole. All that Mr. May is asking is that the law be properly applied to limit the amount of time in which it was proper to file the petitions to recall him. I also expect the committee will explain that they relied on the advice of the clerk. There is another case that states, and I'm happy to provide the citation, it's entitled Emory Mining Corp. Versus the Secretary of Labor. It's a Colorado Court of Appeals case, cited in 2006. And it states that, as a general rule, those who deal with the government are expected to know the law and may not rely on the conduct of the government agents contrary to law. The statute and regulations provide a remedy for other deficiencies in circulating a recall petition, whether those deficiencies are issues with notaries or individual signatures, but there is no provision that's included in the statute or regulations that would allow an extension of time beyond the 60 days for whatever reason. If the legislature wanted to include an exception, presumably they would have. They had the power to do so, but they didn't. Here, Officer Rayner there is no discretion to build one into the statute where it's not already written, especially where doing so would contravene the plain language of the statute. As a result, Mr. May requests that you issue an order that the recall petition is in fact insufficient. Thank you very much for your time.
Thank you. Do you have anything to add, Mr. May, at this time? Okay. Well, then we'll have the committee come up next. If you guys could vacate those seats so we can get them near the microphones.
Oh, I'm sorry, there is one more thing that I talked about with Will and Brett before, and with her permission, I just wanted to make it clear for the record that there doesn't appear, sorry, I'll make sure that I'm
On mic.
I'm sorry to do this. There doesn't appear to be a dispute over the date of which the approval as to form was given by Ms. Harmon, the 24th, or the date that it was in fact submitted by the committee, which was the 26th of January. I'd just like that reflected in the record, that parties are willing to stipulate that those dates are accurate.
Thank you.
Thank you very much. Sorry about that.
Hello. Hello. Yikes.
You're a disaster. Okay. You might grab my agenda. Thanks.
Okay. Willow Rossman?
Yes.
I had spoken to you before the hearing, and I think Leanne might be connected.
She's on the chair right there.
Oh, okay. So I just know that she, there was permission asked for before the hearing that Leanne be able to listen into this hearing, and so that there is a cell phone sitting over there that is actually live.
Yep.
Okay.
She's there.
I just wanted to say it out loud and acknowledge that. Thank you. Please go ahead.
Okay, well, I guess just one note I would like to mention. I spoke to someone in Teller County who also went through a recall. Their petitions were approved on a Wednesday in the afternoon, but they also had a circulation period that would start the next business day, which was that Thursday. So when ours was approved on the 24th, at the end of the day, but approved for circulation starting the very first business day. So I do believe that is something that probably happens in the state of Colorado. I don't know that much about it, but I do know that I spoke to someone in Teller County about how their dates were as well. But just to say, we received the approval letter and approved petition at 3:53 on 11/24, which was a Friday. And then our circulation period was starting 11/27 with a due date on our letter saying that it was the 26th. We honored that. We had it in by 3 on the 26th, when the due date was 5 p.m. on January 26th. And then really, we just wanted to kind of mention, if it would have been approved for circulation on the 24th, we would have gotten one more weekend, so it would have been more beneficial for us to just do it that day. That's all I have.
Thank you. Jackie? I'm sorry. Hello. Oh, these are the petitions? Okay.
They need to be seen. They're not exhibits, they're just, these are voices. Of Garfield County citizens.
Do you have any exhibits to start with?
I do. I can submit them now or after my, they're part at the end of my testimony. If you-
Okay.
However you want to go about that.
I'm okay with you providing them to everyone afterward.
Okay. Good afternoon. Ms. Reiner, Ms. Campbell, thank you for being here on behalf of Garfield County administering this protest hearing. Good afternoon, committee members of the Coalition of Responsible Education in RE2, Mr. Tony May and council, and Garfield County citizens. I'm here today to speak to the accepted 2,441 elector signatures on this petition to recall Tony May from the office of Garfield County RE2 School Board Director E. On March 11th, I received a protest from Mr. Tony May. I've studied the protest, and today I've heard the argument presented by Mr. May's counsel. I disagree with the argument that the petition was not timely filed within 60 days of circulation. I disagree that all sections of the recall petition are invalid and not sufficient. As a designated elected official of Garfield County, it is my responsibility to conduct all elections in Garfield County. A recall election is an election process that stands alone in statute, with its own set of rules. It is my responsibility to guide the committee of citizens with recall statutes and set the timelines of events. As the elected official, it is also my responsibility to be transparent and to keep the committee and the incumbent informed on each statute that we are complying with. I take all of my responsibilities seriously and follow the laws from the Colorado Revised Statute Title I to the best of my ability and to my interpretation. CRS 1-12-108 1.5 is similar with CRS 1-12-108 Both address that no signatures shall be accepted prior to the approval date. Both address that circulation shall not be more than 60 days as approved form to petition. So, my interpretation of these two statutes was that I, as a designated elected official conducting the events of the recall election, that I was responsible for approving the petition and setting the 60 days of the petition circulation, no more than 60 days. The start date of the circulation, November 27th, is noted on the front of the petition. I emailed the letter of approval with the start date and the end date of circulation to the committee. The letter noted the date to begin circulation, Monday, November 27th, and the submit date of January 26th, no more than 60 days. This complies with CRS 1-1-106 computation of time. I also emailed Mr. Tony May on November 24th that the circulation of the petition would begin November 27th of November. Monday, the 27th of November, and that's one of my exhibits, is the email to Mr. May that I'll submit. On November 17th, after business hours, the committee submitted the final petition for my review. Therefore, it was technically received on Monday, the 24th. I had 7 business days from the date to approve the petition. Why did I approve the petition on Friday, the 24th? November 24th was Friday of the Thanksgiving holiday. I came into my office on the county holiday to approve the petition and set the circulation date. Due to the fact that in 2024, I have 3 elections, and then the possibility of a recall election. I needed to consider the time that the election team would need to qualify the petitions before the demands of the March 5th presidential primary election. Per statute, a recall election cannot be within 60 days after a primary. Therefore, if the petition was sufficient with elector signatures, a recall election would automatically be scheduled out to May 5th or thereafter. But then we would also be within 45 days of the June 25th state primary election. So again, I needed to begin outlining the dates and the processes of both elections, complying with Colorado statute. Within the 60-day circulation time, on January 26th, the committee turned in 99 petitions, sections of the petition, with 2 that were voided because it appeared that they were disassembled. Mr. May was notified by email on January 26th that the petition was received. My election team pored over the 97 petitions, inputting all data to SCORE election database. The team qualified signatures by names, address, signature, and the date the petition was signed by the elector. The committee complied with the circulations date set November 27th and January 26th. The petition was deemed sufficient on February 29th with 2,441 valid signatures on the petition. The committee and Mr. May were both notified by the email. On March 5th, Mr. May emailed me and inquired what his next steps were, as he did not intend to step down from his position. I advised Mr. May to ride out the protest period, and at the appropriate time, I would announce a recall election. I also emailed Mr. May the protest hearing statute in Title I. On March 11th, Mr. May filed a protest in my office to where we are here today. Mr. May is stating that he is protesting the circulation dates, when in fact he is protesting the whole recall election that we are now facing. Colorado provides recall elections to voters, which allows eligible electors through a petition to demand an election for the removal of an election official. I have a sufficient petition with 2,441 voters that are calling for a recall election. Title I, CRS 1-1-103, Election Code liberally construed, states that this code shall be liberally construed so that all eligible electors may be permitted to vote. Section 3. Substantial compliance with the provisions and the intent of this code shall be all that is required for proper conduct of an election to which this code applies. To the point of the statute being protest 1-12, 108, 1.5, and 7.5 is not the collection signatures, is to not collect signatures for more than 60 days. The committee complied with that requirement in reliance of my setting of circulation period. Mr. May was aware of the circulation dates, and although he had no obligation to raise objection, he in fact had no objection or communicated any concern. Because the 60-day time frame was complied with, Mr. May has not been prejudiced. Instead, if a 3-day reset of a 60-day circulation period is sufficient to invalidate the whole petition, that runs afoul to the substantial compliance statute of CRS 1-1, 103, 1 and 3. As the designated election official of this recall election, I set the 60-day circulation date. The committee complied. The incumbent, Mr. Tony May, was notified timely with each step in process with no protest. Today I have a sufficient petition with 2,401 valid signatures from Garfield County citizens within the RE2 school district to call for a recall election. It is time to set the date for the election. I ask that you accept into this hearing record the email I sent to Mr. May on November 24th, notifying him the date of the approval of the petition and the start date of circulation. The email I received from the committee on November 17th, the final petition that they sent to me. And I do have copies of 1-103 if you all want that.
I will take a copy.
I don't have exhibit signatures on them for
Okay.
your information,
We can use, we can label them right here.
okay?
So they'll be number 6.
All right, so
And-
this is the email on November 17th from the committee submitting their position one final time.
And this is another one.
6, I made 4 copies.
7?
No, I just have this, it is not an exhibit, but if you think I should share it with, the committee and Mr. May, I'm happy to do so.
Mr. May and Drew, did you record that statutory site that she referenced during her testimony, okay?
Yes, I'm aware.
Do you have it?
No.
So we could give this to Willow. I wrote it down.
Thank you.
You're welcome.
I can even just screenshot it and give it back.
Okay, and I need a copy of that one still. That's what, I have one label left over for number 7. That's
think
why I
it's
was kind
probably
of
mine.
questioning it. Okay.
You have it for 6 and 7.
Do you want a label on yours then? Okay. Oh, that'll make me feel better just to get rid of the last number there. So 4, I've got the exhibits 7 sticker on them. Okay. So we'll give the Jackie a moment to clear her stuff from the desk, and then we'll do a round of rebuttal.
Petition law.
I'm so glad all of these came along.
Recognize Drew Kraniak and Tony May have come back up, and so this will be a time for you to address anything that you heard in either Willow's testimony or Clerk Harmon's testimony and the exhibits that she provided.
Thank you, and I appreciate those comments. I just want to make sure that you are aware, Officer Rayner, of the distinction between the way that the term approval as to form is given in the Colorado statutes that deal with a recall petition, as opposed to the way that the date of first circulation is dealt with. The approval as to form is actually defined in the Colorado Revised Statutes. So that's going to be section 112, 100.5. They provide definitions for some of the terms, and that includes approved as to form. And to quote that section, that's number 1 of 112, 100.5. It says, approved as to form means that the appropriate designated election official has approved the blank form of a petition and has approved the form as meeting the standards set forth in this article. What it doesn't say is that this is the same thing as the first date of circulation. Those 2 days may be the same, they may be separate. That's not provided for in the definition section or in 108, the section dealing with recall petitions. What 108 does say, section 7.5 that you've already read, is that the petition may be filed at any time during the 60-day period after the designated election official's approval as to form of the petition as specified in this section. It does not say 60 days from the designated election official's designated first day of circulation or anything to that effect. If that's what the legislature would have meant, that is what the legislature would have put in the statute. but it's clear and it is unambiguous, and it's not up to you or to me or to anybody else to read something into the statute that isn't there. I agree with Clerk Harmon that recall petitions are to be construed liberally. However, that's not without limits. For example, the Supreme Court of Colorado has determined in a case going back to 1980, it's the Charles Hayward versus Constance Saul case, and just for your reference, that's 619 Pacific 2nd, 499. It states that statutes governing the exercise of the power to recall are to be liberally construed in favor of the ability to exercise it. However, to do so is not to ignore entirely the requirements of those statutes. If you were to allow an extra 3 days, it would be to ignore entirely the requirement of the statute. Clerk Harmon also highlighted a section of the revised statutes, 103, that discusses substantial compliance. But there is no substantial compliance here with the intent of the legislature. Particularly 11103, section 3 states, substantial compliance with the provisions or intent of this code shall be all that is required for the proper conduct of an election to which this code applies. 63 days is not substantially compliant with the clearly stated 60 days that is permitted via statute. Again, if the legislature intended to allow for additional time under various circumstances, it would have been in the statute. It is not in the statute, and neither you nor I have the power to include it in the statute where it isn't. Thank you again for your time.
Thank you. Do you have anything else to add? Okay. Willow Broxman, do you have anything else to add?
I don't.
Clerk Harmon, do you have anything else to add?
I'm gonna, I asked the Garfield County Attorney, Yan Shu, to make a statement.
Okay. Can I have you sign one of the oaths?
Sure. Or it can just be as part of a closing, whatever. Yeah, we'll have to send this one.
Okay. Could you please come up again to notarize for us?
Now I don't see my blank forms. Do you have them?
I don't think so.
You want me to sign? Oh, there's one. That way we'll just stay consistent.
You can.
Jan Schuman? Shoot, sorry. Jan Shoot. From the Garfield County Attorney's Office.
Yes, thank you for letting me speak. It's more in a form of a closing argument than actual testimony, but I am Jan Shute, Assistant County, Garfield County Attorney, Attorney Registration Number 23221, representing Garfield County Clerk Jackie Harmon and her office. As was summarized by Ms. Harmon, CRS 11103 provides the election code should be liberally construed to permit all eligible voters to vote, and in subsection 3, that substantial compliance with the provisions or intent of the code is what is required. I have not found in the court where the courts have reviewed this specific issue as to what satisfies the 60-day signature collection period. But the courts have consistently cited, as was cited in Dodge versus Fremont County, 768 P. 2nd, 1271, that the rule is well established in this state. The right of recall is a fundamental right of the people. Statutes governing the exercise of the power to recall are to be liberally construed in favor of the ability to exercise it, and any limitations on that power must be strictly construed. That's further citing from a Colorado Supreme Court case, Hazelwood versus Saul, 619 P. 2nd, 499. The committee relied on the Clerk Harmon's setting of the circulation period. Clerk Harmon also notified incumbent May. The committee collected for 60 days. Incumbent May now has experienced no prejudice. He's not testified to any prejudice. There was not a longer period to collect signatures or to submit a petition to Clerk Harmon. Mr. May has provided no evidence, and in fact, he just refers to strict compliance with the statute. Clerk Harmon received the petition, and she had 7 days to approve that petition. She could have waited until Monday, November 27, and then there would be no complaint to raise without changing any other facts. Creating a 60-day circulation timeframe, 30 days after the approval date on a county holiday before a weekend, constitutes substantial compliance with CRS 112-108, subsection 7.5, and to receive it, and therefore, we request that the protest be denied.
Thank you. Okay, with that, I'm going to go ahead and adjourn this hearing, and thank you all for taking your time out of your